Good morning and welcome to the third annual Originalism Symposium hosted by the Federalist Society at the University of Virginia School of Law. My name is Rachel Daly and I'm the president of the Federalist Society chapter here at UVA Law. The UVA chapter of the Federalist Society is honored to host so many distinguished speakers to participate in today's symposium, and we thank you all for being here. We're looking forward to some really great discussion throughout the day. Before we get started, I'd like to thank a number of people who made today's symposium possible. First and foremost, I'd like to thank our symposium chair, Connor Kurtz, who has worked tirelessly over the past several months to make this event happen. Second, I owe thanks to the dedicated members of our symposium committee, Nicolo Beltramo, Sophia Evans, Ben Gilman, Teddy Hoffman, Lauren Johnson, Douglas Maggs, William Mahoney, Kanan Mills, Julia Moroz, Christian Slattery, and Killian Wyatt. Finally, I'd like to thank our faculty advisor, Professor Sai Prakash, for his continued support and guidance. Thank you all for making today possible. And now I have the honor of introducing our speakers for our first panel of the day, Textualism after Bostock. Josh Blackman is a professor of law at the South Texas College of Law in Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of 3 books and nearly 6 law review articles, and his commentary has also appeared in numerous national publications. Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy, and he has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He is an adjunct scholar at the Cato Institute, the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, and blogs at joshblackman.com. Tara Lee Grove is a professor of law at the University of Alabama School of Law. She is a graduate of Duke University and Harvard Law School, where she served as the Supreme Court chair of the Harvard Law Review. Professor Grove clerked for Judge Emilio Garza on the U.S. Court of Appeals for the Fifth Circuit, and then spent 4 years as an attorney for the U.S. Department of Justice Civil Appellate Staff, where she argued 15 cases in the Courts of Appeals. Her research focuses on the federal judiciary and the constitutional separation of powers. She has published articles in many top law journals, and her articles are cited and discussed in leading federal courts casebooks. She has also served as the chair of the Federal Court Section of the Association of American Law Schools. Michael Rappaport is the director of the Center for the Study of Constitutional Originalism, a professor of law at the University of San Diego Law School, and founder of the Originalism blog. He has taught overseas in France and Israel, and he is also a member of the Administrative Law and Regulation Executive Committee of the Federalist Society. He worked in the Office of Legal Counsel in the U.S. Department of Justice and practiced appellate law with Gibson Dunn in Washington, D.C. He was a law clerk to Judge Dolores Sloviter of the United States Court of Appeals for the Third Circuit. Thanks again to our 3 panelists for joining us this morning, and I'll turn it over to Professor Grove to get us started.
Okay, so hi everybody. My name is Michael Rappaport, and as Rachel was saying, I'm a professor at the University of San Diego School of Law. So this panel is on textualism and the Bostock opinion. And in Bostock, the Supreme Court held that Title VII's prohibition of sex discrimination also prohibited sexual orientation discrimination and transgender status discrimination. Now, what's especially interesting about Bostock is that it appears to be a dispute within textualism. Justice Gorsuch's opinion for 6 members of the court, including the 4 progressives and Chief Justice Roberts, was written as a textualist opinion. By contrast, Justice Alito's opinion, which was joined by Justice Thomas, and Justice Kavanaugh's opinion, his solo opinion, both concluded that discrimination because of sex did not cover sexual orientation discrimination or transgender status discrimination. But both of these opinions were also written from a textualist perspective. So this raises lots of questions. One question is whether the justices used different theories of textualism or just applied the same theory differently. Another question is, if the justices did use different theories of textualism, what were they and which one was superior? Well, today we have a panel with differing views of textualism and the Gorsuch opinion. So we're going to be speaking first. Professor Grove will speak for 12 minutes, then I'll speak for 12 minutes, and then Professor Blackman will speak for 12 minutes, and then we'll have some back and forth after that. So why don't we start with Professor Grove?
All right, thanks very much. And thanks to the UVA Federalist Society for inviting me. As some of you know, I went to high school in Charlottesville, so it's always nice to be back in Charlottesville, even if virtually. So before I get into the Bostock decision, I want to ask the question, why textualism, at least for me? About 20 years ago, a little over 20 years ago, before I even went to law school, I read a book called A Matter of Interpretation. In that book, Justice Scalia articulates a vision for textualism. He also talks about originalism, something the symposium will cover later on. But I was captivated by his theory of textualism. Justice Scalia said, "It is crucial to look at the words enacted by Congress, not the intentions of lawmakers. That is a way to preserve both judicial supremacy and to constrain the federal judiciary." And as Justice Scalia articulated it, textualism was not an ideological project. If judges were interpreting an environmental statute or a civil rights statute, they might reach progressive conclusions. If they were interpreting a different statute, they might reach conservative conclusions. It was not an ideological project. It was a rule of law project, and one that I found captivating. So fast forward a number of years. For much of my career, I've explored the separation of powers, but only in the last couple of years did I get into statutory interpretive theory again. Started with a project on presidential directives, and then most recently with a project on the Bostock decision and textualism. What I found a couple of years ago, even before Bostock was in litigation, was that there were serious divisions among textualist scholars and theorists and judges. And I felt like these divisions were largely below the surface, and they came out very much in the Bostock decision. And that led me to write a paper entitled "Which Textualism?", which uses this recent Supreme Court decision to examine competing theories of textualism. So what are these theories? I view the decision as a division between formalistic, what I call formalistic textualism, and flexible textualism. Now, I want to be clear, these aren't necessarily different categories, although you can think of them that way. You can also think of them as ends of a spectrum. Versions of textualism can either be more formalistic or more flexible. But either way, I think that the Bostock decision really underscores these divisions. So, Bostock versus Clayton County, as I think many people know, asks the question whether the disparate treatment of a gay, lesbian, or transgender individual qualifies as discrimination because of such individual sex under Title VII of the Civil Rights Act of 1964. The majority opinion, written by Justice Gorsuch and signed on by Chief Justice Roberts and 4 other members of the court, the majority opinion applied what I call formalistic textualism. The majority opinion is zeroed in on the language of Title VII and said, terminating a male employee because he is romantically attracted to men when an employer would not terminate a female employee who was romantically attracted to men, or dismissing an employee after she announces her transition from male to female. These examples seem like instances of discrimination because of such individuals' sex. And that is what the majority opinion held. And it is important for my purposes, not only what the majority opinion did say, but also what it declined to look at. So the majority opinion did not look at the social context in 1964. The majority opinion did not examine how people in 1964 might have expected Title VII to apply. Nor did the majority opinion look at the potential practical consequences. In fact, Justice Gorsuch said, we're not going to look at how our interpretation of this language might affect other situations like sex-segregated bathrooms or dress codes. These are issues that are not only not before the court right now, But we can't change our interpretation of a statute based on what might be deemed by some to be undesirable consequences. We focus on the statutory language, and that's that. So that was the majority opinion. The dissenting opinions offered what I call a more flexible textualism. I do think one can think of these opinions as a version of textualism, although some have questioned that. I think one can think of these as a version of textualism because they do focus on the text as a focal point and avoid resort to legislative history. But these opinions looked at a lot of other things to make sense of that text. So Justice Alito said we have to look at social context. In fact, he said in his opinion, quote, "When textualism is properly understood, it calls for an examination of the social context in which a statute was enacted, because this may have an important bearing on what its words were understood to mean at the time of enactment. For this reason, it is imperative to consider how Americans in 1964 would have understood Title VII's prohibition of discrimination because of sex," end quote. Justice Alito went on to say that, quote, "The answer could not be clearer. In 1964, ordinary Americans reading the text of Title VII would not have dreamed that discrimination because of sex meant discrimination because of sexual orientation, much less gender identity, period," end quote. And Justice Kavanaugh also said it's important to look at common parlance, how people would have used the words both in 1964 and, he said, thereafter. These opinions said what matters is not simply what the words say, but also how people at the time would have expected those words to apply, the social context. And Justice Alito underscored it's also vital to look at the practical consequences. In fact, he criticized the majority opinion for not focusing more on the practical consequences of the decision. He said there would be major implications for dress codes, sex-segregated bathrooms, for religious freedom, for freedom of speech, and added to his opinion an appendix that listed 100 statutes that he said would be affected by the majority's interpretation. So, okay, we have these competing versions of textualism. Which is better? Well, I advocate the more formalistic version. And that's not only because I think that's a better way of understanding the words enacted by Congress pursuant to its Article I lawmaking process, but also because I think that is the better approach for the federal judiciary, given its role in our constitutional scheme. And here I want to focus on Article III and judicial legitimacy, and also some tensions that I see between the Article II appointments process and Article III. So what do I mean by that? Well, the Constitution creates a federal judiciary that is both infused with politics and that is also supposed to be independent of politics. Articles 2 states that the president shall nominate and by and with the consent of the Senate shall appoint justices of the US Supreme Court. So there is a political process for selecting members of the US Supreme Court and other parts of the federal judiciary. But then Article 3 says that those justices shall have tenure and salary protections, an indication that upon assuming offices, the justices are supposed to be independent of the very political forces that gave them their jobs. In recent years, people have seriously questioned the independence of the federal judiciary. We hear from both sides of the political aisle the calls about Trump judges and Obama judges. The implication being that judges will decide cases in accordance with the preferences of the appointing president, maybe not in accordance with their own views of the law. And where does this come from? Well, over the past several decades, presidents have been trying to appoint justices that they think will decide salient cases in ways that the presidents prefer. Democratic presidents try to appoint reliable progressives. Republican presidents try to appoint reliable conservatives. Both sides are trying to avoid so-called swing justices who might surprise the appointing president. At the same time, there are social pressures on justices. Neil Devins and Larry Baum recently wrote a book that showed how conservative justices tend to go in conservative elite circles. They go to Federalist Society events, whereas progressive justices go to American Constitution Society events and hang out with progressive elites. These elite circles reinforce, these authors argue, the notion that justices should decide cases in accordance with their political team. The assumption underlying all of this is that the Article 2 appointments process will dictate the outcome of salient cases rather than the judge's views on the law. To my mind, this is highly problematic. And how do we get out of it? Well, I advocate formalistic textualism as a way for judges to zero in on the semantic context of a statute and put to the side, try to put blinders on with respect to social context, policy context, concerns about practical consequences, the very concerns that the outside groups ask the justices to focus on. This happened in Bostock. After Justice Gorsuch indicated that he thought the text of the statute favored the plaintiffs, some commentators on social media said that that would be an unprecedented betrayal for him to go along with the text of the statute as he saw it. I think the formalistic textualism of Bostock is a way to answer concerns about judicial legitimacy and ensure that justices will not always decide cases in accordance with the preferences of the appointing president. Now, I do recognize it's not clear that this constraint will actually work. I think there are a lot of doubts in our society right now on many sides of the political aisle about whether judges really can separate themselves from their political perspectives and try to focus on what they think is the best answer under the law. And so I can't guarantee that any approach is going to ensure that judicial discretion will in fact be cabined. But I view my role as an academic to advocate for the ideal in the hopes that real world judges will come as close to that ideal as is possible. And I see Bostock as an indication that judges are capable of coming closer to that ideal than I think many people expect. And here, in my view, this is a way to get back to the origins of textualism, not as an ideological project, but as a rule of law project, and to ensure that judges will come as close as possible to exercising the political independence contemplated by Article 3. And I will stop there.
Okay. I'd like to thank the Federalist Society, Virginia Federalist Society, for all the work that they've done and for inviting me. Today, I want to criticize Justice Gorsuch's majority opinion in Bostock. And in my view, the opinion is pretty clearly mistaken about the original meaning of Title VII, and also has some problematic things to say about textualism. But let me start off with 3 qualifications. First, my argument is about the original meaning of Title VII. It's not about the policy question, whether it's a good idea to prohibit discrimination based on sexual orientation. In my view, there are very strong arguments for prohibiting discrimination based on sexual orientation whenever it makes sense to prohibit discrimination based on sex. But that's not our question today, and that wasn't the question for the court. Second, I'm a big fan of Justice Gorsuch, and while I believe his Bostock opinion is pretty bad, I believe this is an aberration. After all, even Homer nods. And third, while people talk about textualism as the statutory interpretation and originalism as the constitutional interpretation, I'm going to talk about statutory originalism instead of textualism. Statutory originalism is what I believe in, and I think it's a less misleading term, a more accurate term than textualism. So let me start out by explaining what I believe the correct resolution of the case should have been under statutory originalism. In my view, the term discriminate against because of an individual's sex was largely unambiguous in 1964 as to whether it covered discrimination based on sexual orientation. And I'm going to talk here, as I have been already, I'm just going to refer to sexual orientation, and people should understand that to also include transgender status. So at that time, it seems pretty clear based on language usage that sex discrimination did not cover sexual orientation discrimination. And this is true both for the ordinary meaning and the legal meaning. Now, this result based on language usage is strongly reinforced by the values of people at the time. In 1964, there was strong opposition to homosexuality, which was generally illegal, was widely regarded as immoral, and officially treated as a mental illness. Now, it seems extremely unlikely that people at the time would have sought to protect individuals in this group and to protect their behavior. Now, it's taken many years for our society to change its values on this issue. But if we're going back to the time when, as we should as originalists, the time when this was enacted, we have to understand that background. Okay, well, if these arguments are so strong, then how does Justice Gorsuch reach a different result? Gorsuch claims that the plain meaning of discrimination against someone because of their sex covers any differential treatment between employees that draw a distinction based on sex. So if an employer fires a gay male employee, but not a straight male employee, that constitutes discrimination because of sex, because the gay employee is attracted to men, while the straight employee is attracted to women. Now, this is certainly a possible understanding of discrimination because of sex, but was it an actual meaning in 1964, not to mention the only or clear meaning at the time? There's significant evidence that it was not. So how does Justice Gorsuch reach the opposite result? Well, first, he claims that his understanding of sex discrimination is the ordinary meaning of the term. Some people, such as Professor Blackman on this panel, have reasonably interpreted this language to mean the ordinary language meaning as opposed to the legal meaning of the term. In other words, he's looking for what an ordinary person as opposed to what a lawyer would believe about that language. Now, if that is what Gorsuch meant, then his opinion is quite strange, because after making this claim that he's going after ordinary meaning, he then goes on to consider not ordinary meaning, but legal meaning. He considers the legal meaning in at least two ways. First, he applies a but-for causation standard to understand discriminate against because of sex. But but-for causation is a legal standard. It's not an ordinary meaning standard. Doesn't capture the way people use causation all the time. Second, he then confirms his analysis by considering later Supreme Court cases. But later cases, and I might add, decided by non-originalist courts, are hardly good evidence of the original ordinary meaning. But Gorsuch actually may not have meant the ordinary meaning in this way. Instead, he might have simply meant the meaning that would typically or regularly be given to language. This typical meaning might be the meaning given to it by ordinary people, such as non-lawyers, or it might mean the meaning that lawyers typically give to it, what we might call the legal meaning, the ordinary legal meaning. So under this latter interpretation of Gorsuch's opinion, he could be seeking the original legal meaning of the term. But even if Gorsuch had applied an original legal meaning standard, his argument still does not work. There's really no evidence that legally knowledgeable people in 1964 would have understood sex discrimination as having a legal meaning that covered sexual orientation discrimination. Justice Alito's dissent mentions many constitutional provisions and laws at the time that prohibited sex discrimination without being understood to prohibit sexual orientation discrimination. For example, the Immigration and Nationality Act prohibited sex discrimination, yet it was interpreted to discriminate against gay people. Since the evidence from usage in ordinary language and in legal language is quite powerful, one might ask what Gorsuch was thinking. And in my view, Gorsuch adopts a literal meaning view of discrimination because of sex. But while this literal meaning could have been employed by the authors of Title VII, Gorsuch needs some original evidence for it, and he never supplies it. He seems in the grips of a kind of logical vision. Because of sex must mean but for causation, as a literal matter. But as Justice Kavanaugh points out, literal meaning is often wrong, especially for phrases. As he says, a washing machine could literally refer to a machine used for washing any item. But in ordinary speech, it means a machine for washing clothes. And Gorsuch never confronts the problems with his literal meaning analysis either. So neither Justice Gorsuch nor the court is likely to apply this literal meaning in many future cases. For example, imagine a cisgender female is fired from her job as a lifeguard because she wants to go topless. Now, even if the male lifeguards are allowed to go topless, the female lifeguard is unlikely to be able to claim she was subjected to illegal sex discrimination. Yet Gorsuch's analysis would seem to require it. Now, to pursue his literal meaning vision, Gorsuch attempts to criticize the strong evidence from language usage and values. But both of his arguments here are problematic. Let me start with usage. First, Gorsuch does not really seem to think, I guess I'd say, that the usage evidence is relevant. He seems to dismiss it, thinking of it as purpose evidence or something similar that is inconsistent with textualist originalism. But evidence of usage and understanding is not secondary evidence. It is primary evidence of original meaning. Let me repeat that. Usage evidence, how people use the terms, is primary evidence of original meaning. It's true that what is sometimes called expected applications can be bad evidence. If people expected a result that was inconsistent with the language, or that was based on a mistaken factual understanding, then of course we shouldn't follow it. But that's not what's going on here. The language does not unambiguously cover sexual orientation discrimination. Second, Gorsuch dismisses evidence from a hypothetical conversation. This is some of the way he dismisses usage evidence. He admits that if someone was fired from their job for being gay, they would not describe it as being fired for sex discrimination. But Gorsuch chalks that up to the fact that in ordinary informal conversation, people do not often provide all of the reasons why they were fired. But this is a weak argument. Even if the setting was a more formal one and a more comprehensive one, in a more legal or formal manner, Gorsuch provides no reason to believe that people would describe the firing as sex discrimination. It's not that they are not giving all the reasons, that simply wouldn't have been one of the reasons that they would have thought of it that way. Now consider values at the time. Gorsuch seems to believe that people's values are irrelevant to interpreting the law. But this is only true in a very limited sense. If statutory language is unambiguous, then I agree, one should not consider the values, except perhaps to the extent that the words might lead to an absurd result. Put that to the side. But if the words are unclear, then one must choose between different meanings. And it is perfectly legitimate to consider the values at that time, the values at the time, for two reasons, if the words are unclear. First, people are unlikely to enact laws that promote values that they strongly disagree with. Thus, the prevailing values can sometimes provide strong evidence of the meaning of a law. So if there's two usages, and one of them would lead to something that people are very unlikely to have done, and the other one leads to something that they are very likely to have done or likely to have done, then you would choose the latter. Second, it's perfectly legitimate to resolve an ambiguity in a statute by reference to statutory purpose. And the values at the time often provide some evidence of purpose. Finally, let me say some people have criticized using this evidence of language usage purpose, values as undesirable on the ground that such evidence can be used against vulnerable minorities. And I agree, this is certainly a possibility, but it's not the only danger. Finding a meaning that is not the real original meaning because one pursues a literal or theoretical meaning is another danger too. And that can harm minorities as well. So the best way, I think, here is to guard against these various dangers is to attempt to determine the original meaning as accurately as possible. And in this way, an interpretation can be tested by something that can be assessed as correct or incorrect. So in the end, I probably do not disagree so much with Gorsuch's general approach, although I do a bit, as much as with its application in Bostock. His literal language approach in Bostock did not discern the original meaning, and that approach is as dangerous as anything else that he criticizes. Okay, so we now have Professor Blackman.
Thank you so much, my good friends, Professors Grove and Professor Rappaport. I'm honored to be here. Also to the UVA FedSoc, thank you for having me. I spoke here last year. I remember there was a snowstorm that day. I almost got stuck in Virginia. I finally got home. So it's good to be here, at least in Houston, where it's not snowing yet, at least. My talk will focus on the relationship between textualism and stare decisis. In Bostock, Justice Gorsuch insisted he was sticking to the text, the whole text, and nothing but the text. He wasn't. His interpretation was shaded by the work of justices who had not been so careful about text. Justice Gorsuch failed to acknowledge that the court's precedents were inconsistent with textualism. In doing so, I think he inadvertently undermined textualism's justification. One can't profess to follow the original meaning of a text while in fact following precedents that ignored that meaning. Going forward, Justice Gorsuch should criticize prior decisions that failed to take text seriously and either follow them reluctantly or formally abandon them. All right. In Bostock, Gorsuch parsed the text of the Civil Rights Act of 1964. This statute made it unlawful for employers to, quote, discriminate against employees, quote, because of sex. Justice Gorsuch did not begin his analysis by interpreting this text on a blank slate. Rather, he simply assumed that decades of case law had accurately interpreted the crucial phrase, discriminate against because of sex. Indeed, he treats decades of precedent as part of the law's, quote, ordinary meaning in 1964. This approach built an elaborate textualist framework on quicksand. Today, all 9 justices agree that the court must determine the meaning of a statute, regardless of whether that meaning leads to a policy that is unjust or unwise. In this case, my view is that the phrase discriminate against must inform the meaning of because of. Recently, there was a movie about Justice Ruth Bader Ginsburg called On the Basis of Sex. This title was an homage to the widespread understanding of what it meant to discriminate against a woman on the basis of sex. When these elements are combined, the phrase discriminate against because of sex references discrimination based on bias or prejudice about a person's sex. It does not reference discrimination based on sexual orientation or gender identity. Title VII cannot be dissected like a frog in a freshman biology class. The phrases discriminate against and because of are closely intertwined. The whole conveyed more meaning than the sum of its parts. This concept did not refer to blindly treating a man differently than a woman. Rather, the standard made bias or prejudice an essential element of the causal injury. Yet, Justice Gorsuch relied on decades of precedents that focused primarily on because of, and not the entire clause. Doing so eliminated the requirement that some sort of bias or prejudice exists based on a person's sex. In effect, he severed the statute in half and concluded that if sex plays any role in the discrimination, the employer's actions are unlawful. Randy Barnett and I have described this approach as, quote, halfway textualism. Gorsuch followed old precedents, narrowing a small component of the statute, even when those cases are at odds with the meaning of the entire statute. Here, Justice Gorsuch quietly accepted precedents that paid little attention to text. I believe he erred. Generally, the Supreme Court will stand by precedent. It's what lawyers call starry decisis, which is a topic for maybe another panel. Textualists and originalists have a tough time with stare decisis. In many instances, the text of a statute or the Constitution has a meaning that conflicts with the court's long-standing interpretation. Or perhaps the court has adopted a method of reading a statute that requires consideration of extrinsic factors, such as legislative history or policy concerns. What is a textualist to do? I think there are three general approaches. First, the textualist can acknowledge the conflict between text and precedent, but maintain that stare decisis compels a result that conflicts with textualism's basic principles. This approach has a virtue of humility, even if it reaches the, quote, wrong result, at least by a textualist standard. Second, the textualist can overrule the non-textualist precedent in order to enforce a statute's natural sense. Here, stare decisis gives way to textualism. This approach has a significant downside. It disturbs arrangements that people have come to rely on. Yet at least this approach has a virtue of candor. The jurors can explain the why and how they're departing from settled law. And look, I'm a professor. I find this honesty refreshing. On the current court, Justice Clarence Thomas is the member of the court most likely to take door number 2. Justice Gorsuch, however, favored door number 3 in Bostock. He professed to apply a form of unadulterated textualism, but he failed to take account for contrary precedent. You see, in Bostock, Justice Gorsuch quietly baked into his analysis decisions from the 1980s and the 1990s that were hardly textualist. Let's start. To define discriminate against, Justice Gorsuch relied on a 2006 decision from Justice Breyer, which stated, quote, no one doubts the term discriminated against refers to distinctions or differences in treatment that injure protect individuals. But Justice Gorsuch was interpreting a different provision of Title VII that governed retaliation. It wasn't the provision at issue in Bostock. Moreover, Justice Breyer made no effort to understand how discriminate against was understood in 1964. Instead, what did Justice Breyer rely on? Justice Brennan. Justice Brennan wrote another case in 1989. But this case didn't turn the meaning of discriminate against at all. Rather, Brennan considered the phrase because of. Justice Gorsuch's research trail slammed into a brick wall. You start with text and you wind up with Brennan. And that's basically why I think the opinion's wrong. Yet, despite this incomplete analysis, Justice Gorsuch concluded that the phrase, quote, to discriminate against a person would seem to be treating that individual worse than others who are similarly situated. Now, this is not statutory originalism, to use Professor Rappaport's phrase from a few moments ago. This is some form of textualism or halfway textualism, as Randy and I call it. Now, Justice Gorsuch repeats over and over and over and over again that Congress can amend a statute if it disagrees with the court's decision. Of course it can, but that argument only goes so far. Okay? Congress has been operating under certain assumptions for decades. It thought that the scope of Title VII had been settled long ago. But Justice Gorsuch maintains that everyone was wrong about Title VII for 5 decades. I think you can depart from this method, but you need to address why you're departing from these methods. My disagreement here, though, is methodological. Textualism, like originalism, must start from the blank slate of a statute, without regard to how the court has interpreted that statute in the past. Justice Gorsuch, to use a football analogy, for those who like football, Justice Gorsuch cannot begin from the 50-yard line. He must start from his own end zone. In its present form, Justice Gorsuch's textualism is far too fragmented to form coherent jurisprudence. In the future, he must grapple with the interplay between stare decisis and textualism. When feasible, he should choose door number 2 and reject precedents that ignore textualism. If that approach is not viable, he should stay behind door number 1 and at least cast doubt on why that precedent is flawed, but follow it anyway. Door number 3, though, is misleading. It preaches textualism, but practices precedentialism. Not presidentialism, precedentalism. If that's even a word. It is now. This approach, in the long run, will serve only to undermine textualism. If Justice Gorsuch wants to move the law away from nebulous, flimsy reasoning toward more textualist, neutral principles, he must account for both text and precedent. He cannot rely on the analytical reasoning of Justice Brennan. Thank you so much, and I look forward to a discussion with my colleagues and the students and other people in attendance.
Okay, so why don't we give the panelists a chance to say anything to their, or respond to, or say anything to the fellow panelists for a little while. Professor Grove, you want to start?
Sure. I think that, you know, what's great about this conversation is that we're underscoring how there are different perspectives on textualism. And in my recent paper, Which Textualism, that was one of the things I wanted people to talk about, because I think that up until that point, there had just been this notion that there was this textualism thing that some people signed on to and a lot of people didn't, at least in academia. And I think there are a lot of disagreements. So, you know, I think Professor Rappaport's argument very much goes along the lines of Justice Alito's dissenting opinion, that the important thing is to look at the social context of 1964. And I think that that is a very mistaken approach to textualism. I think what's important is the words that Congress enacted, not the way that people at that time expected them to apply to particular instances. I think that's particularly important in the context of something like sex discrimination, where nobody in 1964 probably had a good idea of how it would apply. So just to give people some examples of how courts originally applied Title VII in 1964. Courts rejected sex discrimination claims when women, but not men, were barred from employment for getting married or having young children. Why did the district courts do this? Because they said the discrimination is not about sex. The discrimination's about marriage or motherhood. Courts also said that sexual harassment, wasn't even really a thing, and certainly was not sex discrimination. Now, think about this. At the time, the court said, well, nobody would say that refusing to hire a woman because she has young children is sex discrimination. It's about her motherhood. That's what you would call it. It's discrimination on the basis of parenthood. And an understanding that in our society, men and women are simply differently situated when it comes to their role in rearing young children. I think there are many analogies to that argument, to this notion that, well, sex discrimination can't encompass discrimination against a gay, lesbian, or transgender individual, because that's not the way people talk about it. People talk about things in lots of different ways. The words that Congress enacted, I think, had much more dramatic implications than people in 1965, 66 were willing to admit, and than people today are willing to admit. I also want to say a quick word about Professor Blackman's comments. I think you make some extremely important comments about stare decisis and textualism, and this is something that textualists need to deal with. I do want to say a bit of defense in Justice Gorsuch's I would just want to say a word in defense in Justice Gorsuch. When he defined discriminate, the first thing he said was, what did discriminate mean in 1964? So he was focused on what he viewed as the original meaning. He says, as it turns out, it meant roughly what it means today, quote, to make a difference in treatment or favor of one as compared with others, end quote, and quoted Webster's New International Dictionary from 1954. Now, he did then also mention the 2006 case, but I think it's a bit unfair to say that his opinion was exclusively about precedent. A lot of most of his opinion said, let's look at what the words originally meant. Obviously, there's room for disagreement about what context you look at. And most of his discussion about precedent was later on saying, hey, look, my interpretation of the words is also consistent with what we have done.
So, thanks. So I guess I have two things to say really in response to Professor Grove here. The first thing is, what is the role of usage analysis? Now, every time that someone brings up usage, either Justice Gorsuch or Professor Grove will then sort of talk about it as if it's people's values. There is a values question here, but that's a separate argument. If we're going to understand what the meaning is of a term, we have to look at, I don't really think there's any other way to do it, is how it's actually used. Some of that is in dictionaries, some of that is we actually see how people, when writing about it, if we can infer what their meaning is. And if you're not using usage, I don't understand what it is, how it is you're figuring out the meaning of a term. Now, I agree, Justice Gorsuch's understanding of that language could possibly be, it's a possible meaning of the term, but it's not the only possible meaning of the term. And the usage argument there, the examples that one talks about, that are talked about by Justice Alito, as well as by Justice Kavanaugh, that's different than expected applications. So there's a primary thing we're trying to do is figure out what the meaning was, and unless we're looking at how people use the terms, what the meaning was at a particular time, that's how we figure it out. So I guess I think that's the biggest sort of gap here between the different approaches. So I want to ask Professor Grove, do you accept usage discussions? Now, well, why don't I leave that there? I do want to make another point about values, but I don't want to put them together since I think they need to be separated out. So let me leave it there, and either Professor Grove can respond or Professor Blackman's chance, however we want to do this.
Tara, go ahead. That's for you.
Okay, so I think it's very, very hard in this context to separate usage from values, post-enactment usage. I don't want to make a broad statement that that's always true of usage, because I would want to give that a lot more thought before I made a blanket statement. But I think in this context, usage and expected applications are largely the same. And I think this is particularly a context, we're talking about how people refer to their discrimination, and I'm trying to think of instances of discrimination based on sex today. It is true that there is a movie on the basis of sex, very good movie, by the way, for those who are interested. I don't actually know many people who today would say, because they might say, I was fired because I'm a woman. I was fired because of the way I dressed. Probably wouldn't use the term sex discrimination. So I think that's a difficult thing. I think it is a legal term. The concept of sex discrimination. And I think usage, as the examples that I just described, where discrimination against women for having, refusal to hire women who had young children, firing women who got married, that was deemed by some courts discrimination on the basis of motherhood and marriage. The usage at that time would have completely obliterated the possibility of something that today we view as clear sex discrimination. And I suspect both of you would agree would have been sex discrimination under the original meaning in 1964. So I really don't think there is a distinction between expected applications and usage at the time.
If I could jump in for a minute?
Sure.
I think Professor Grove raised a fair point. Maybe the entire edifice of modern discrimination law is wrong. I mean, I look at decisions involving sexual harassment and Weber and disparate impact. I'm like, that's not a statute. Maybe Congress should have enacted a dozen Civil Rights Act instead of trying to cram everything to Title VII. Maybe the decisions in the 60s were actually more authentic. They were there at the time. They had a better sense of what these words mean. Maybe it wasn't motherhood. I don't know. I haven't looked into it carefully. If that's the answer, we should enact more statutes to remedy different types of evils. When we look at Justice Scalia and the Enclave decision, he was relying on textualism, but there was precedent there about what sexual harassment is. Scalia couldn't just say no sexual harassment at all. Maybe the answer is there was no sexual harassment protections, and this is why if you're going to be door number one, door number two, number three, we just say stare decisis goes away, and we don't follow it. But once you start from the premise that we're baking in these old precedents, then I think you're sort of locked into sort of this this sort of Gorsuchian approach to the original meaning.
So keep in mind, I'm talking about precedents that I think were clearly wrong, but were decided by district courts much, much closer than 1964 than some of the Supreme Court precedents you're citing. So I actually think those precedents were incorrect and had a very had an incorrect understanding. Now I think it's valuable what you just said, that one could take Justice Alito's opinion or Justice Kavanaugh's opinion and say not only were they correct, but everything else that the Supreme Court has done is absolutely wrong. That would be an extraordinary implication. I don't think that's the proper meaning of Title VII, but that would be an interesting paper to write. But I also want to point out one other thing. There's this assumption in Justice Kavanaugh's opinion, because he explicitly says, I'm going to talk about sexual orientation, not gender identity. So I'm going to only talk about gays and lesbians, not transgender individuals. And then he goes on to say that, look, it's a unanimous circuit court opinion. Every court to have considered this prior to 2017 found that sexual orientation discrimination was not covered. But actually, judges much earlier than that found that discrimination against transgender individuals was sex discrimination. District courts found that, dissenting judges found it. It was not found by a majority of courts for a long time. But in 1977, Judge Goodwin, who was an appointee of President Nixon, he dissented in an opinion involving a transgender individual. And he said, he quote, agreed with the majority that Congress probably never contemplated that Title VII would apply to transsexuals, but quote, by its language, the statute prescribes discrimination among employers because of their sex, end quote. And here the plaintiff, quote, alleged that she was fired for being or becoming female under circumstances that allegedly disturbed her fellow workers and therefore motivated her employer to terminate her employment. That was 1977. And a judge was saying, yeah, this is sex discrimination, even though that's not what Congress had in mind. So I think it's a misnomer to say that suddenly the Supreme Court in Bostock invented this interpretation. Rather, this was something that was hidden below the surface. And the people who used that interpretation were the ones who were more textualists at the time, and it was purposivists in those early days who rejected it.
So I guess I'd say, so let me tell you a quick thing about that and then raise my other point. I agree, it's a possible understanding of the term. But the question, there was usage, perhaps just a little bit of usage. You've got that 1977 opinion. It's already 13 years later. Yeah, there might have been a little bit of usage that viewed it that way. The overwhelming amount of usage would go off in a different direction and say that either transgender or sexual orientation wasn't that. So we got to look at which was the more common usage, and then to figure out the meaning. That's not, I think, what Justice Gorsuch does at all. I guess the point I want to make about the values at the time, so here we are today, and I had my example about the female lifeguard, the cisgender lifeguard who wants to work topless because the men can. Now, I had a little exchange about this with Professor Andy Kopelman from Northwestern, who's really one of the authors of the theory that Justice Gorsuch gives in Bostock. And he said, oh, well, that wouldn't be decided this way now. No one will interpret Title VII to protect the cisgender female lifeguard. So one needn't worry about it, which was sort of one point. And I said, well, that might not be interpreted that way today, but let's go 20 years into the future, and we have a sort of political movement. We don't hear quite that much about it, but we hear a political movement that women should be able to go topless because men do so in public, right? And there's cases that come up. If that comes to be accepted by the courts, then you can easily imagine someone saying 20 years from now, having this conversation, saying, and you wouldn't interpret the original, in the same way that we view sexual harassment and dismissals for motherhood. Those things might not have been in the original meaning. They seem wrong to us now, just as 20 years from now, it might seem that firing somebody because they're going topless will seem will seem like it should be covered by sexual equality. So and my sense is that the values have changed. We look at those results. We like the results, but that doesn't mean that they were the original meaning.
So I'm going to go back to that, and I think there are some dangers in allowing judges to think about usage in 1964. It's particularly hard in the context of a case like Bostock, because even the term sexual orientation and gender identity didn't really exist at that time. There were other, what we can now consider to be more derogatory terms that were used at the time. I think you make a valuable point that Title VII in my view, was a revolutionary statute and had some implications that many members of Congress, even those who voted for the law, could not possibly have anticipated, including that people might not be fired, women might not be fired for having young children. There were probably some members of Congress who would have said, well, of course they should not be hired if they have young children, or they should be a stewardess, and they were all stewardesses then, should be fired if she gets married. But that's to me what textualism offers. There are words that many members of Congress don't anticipate. And it is true that it may end up being something that we don't necessarily assume is going to happen in the future, but yet that's what the words mean. And that to me is the beauty of textualism, that it can be something that leads to conservative results in some cases that are surprising and progressive results in other cases that are surprising, and some that we can't anticipate. Now, one important thing to note about Title VII itself is it does include an exception for bona fide occupational qualification. And so when an employer needs to do something in order to further that particular employer's ends, there actually is an exception there. So there's an exception written into the statute. There are exceptions for religious employers as well. So this isn't a statute that necessarily applies in all contexts. And I think there's lots of room for disagreements. But I do think that when Congress enacts words, those words may lead to consequences that members of Congress did not anticipate and members of the public did not anticipate. And we get too fixated on the world of 1964, the values of 1964, then we prevent those words from having the meaning that they naturally do.
Okay, I'm gonna now move to because we're past time on this, to the question and answer portion. Take some questions from the audience here. I've got a list of them, and I don't really have a chance to read them all in advance, so I'm just gonna start to read some, and then we'll see where we go from there. So Gary Oldoff asks, could Justice Gorsuch's decision be justified if Congress periodically readopted the statute and had done so, say, in 2015. So I think maybe that's a question for you, Professor Blackman.
Yeah, I can answer that. Thank you for the question, Gary. When Congress reenacts a statute, I think that does affect the originalist analysis because you're sort of incorporating the meaning at that given time. And look, 2015 was not 1964. We were post Lawrence. We were post Windsor. We're on the cusp of a Obergefell. Or no, Obergefell already been decided. So this would be a very different world. I think Gorsuch tried to suggest in his opinion that there were times when Congress reenacted elements of the statute. Although I'm not sure if the discriminate against because of was modified, I can't recall. But I do think reenacting the statute makes sense because it does sort of incorporate a more modern sense. And I think Congress can sort of push back against the courts. The Civil Rights Act, was it 1990 or 1991, basically said the courts screwed things up, and then Congress screwed things up even more. So it made basically a hash of employment law. But I wish Congress would be more assertive and actually tell us what they think rather than having to glean at the interstices of 60-year-old statutes.
Okay. I have a question from Andrew Abraham. I have a question for Professor Grove. How far does formalistic textualism go? Should we read all statutes with the linguistic meanings of the words we have today? That's one part of it. And then is it any different from literal meaning interpretation? So is formalistic textualism any different from literal meaning interpretation?
So I don't think it's literalism. And I think one of the examples I give in my paper is the 1871 statute, also known as the Ku Klux Klan Act, that uses the term domestic violence. The president has the power to suppress domestic violence and insurrections in states. If we take that literally, according to modern meaning, we might say that the president has the power to go after tragic abuses within a family. But that is not, that literal meaning is not, in my view, the better reading of the text. Rather, we read the text in context. Domestic violence is a long insurrection. And also we know from our history and culture that the term domestic violence can mean a violent uprising. And so when you take that knowledge alongside the semantic context, you do not get what might be a literal interpretation. So I don't think this is literal meaning. Yeah.
Okay. Let's see, from Douglas Maggs. Over the past several decades, some members of Congress specifically tried to add sexual orientation and gender identity to the list of groups protected from discrimination under the Civil Rights Act, perhaps suggesting that those members were not convinced that their predecessors had included these protections in the Act in the first place, or at least that they did not expect the court to find these rights in the Act. Where will the Supreme Court go from here with Bostock now as precedent? Are the remaining initiatives of the proposed Equality Act merely a case away from also being found by Justice Gorsuch's methods in longstanding acts or law?
I'll take that one. It's about Congress. I think the history of Congress failing to enact the Equality Act is useful, but I can see why people say it's not. The fact that Congress chose not to enact the statute perhaps reflects that they already did it. They don't need to pass a new statute. It's an argument. I don't like that argument, but it's a contrary argument. I'm worried about Justice Gorsuch. In another case decided last term called McGirt, he pulled a similar move. He took a very old statute governing Indian law, and he read it in a way that had never been read before in sort of this hyper literal fashion. And the effect that decision won't affect me and you, but for our friends in Oklahoma, half the state is now basically under Indian territory, and it creates a lot of uncertainty about what exactly that even means. I don't know where this sort of literalism, whatever you want to call it, leads for Justice Gorsuch. I don't know what's next. I'm scrolling down to another question on the list from Jesse Mann, who says, what other litigation strategies can we pursue to take advantage of the textualist majority? Look, the court's conservative, at least on paper, but you get a fifth vote for Gorsuch by having these sort of wonky interpretations. If you get it in his head that this is textualist, you get your fifth vote, or maybe a fourth vote now, depending on how Barrett swings. But I think Gorsuch may do things that Professor Rappaport said this was an aberration. I hope he's right. But I think Gorsuch will keep doing this for a very long time.
So can I say a couple of things in response to that? So to me, cases like Bostock and McGirt are a beautiful thing for the federal judiciary. And the fact that Justice Gorsuch is not a reliable conservative vote, I hope that Justice Barrett won't be a reliable conservative vote in statutory cases. I hope that Justice Kagan will not be a reliable vote a reliable progressive vote in statutory cases. I think that is a good thing for the federal judiciary. And it worries me a lot when people complain that that's a bad thing. I also want to say on the post, I think it's dangerous to look at post-enactment legislative history, and congressional silence is telling us much at all. So I just wanted to say that. But
I don't think that was I think my point was an aberration from textualism. I don't think I said he was being a bad conservative. I don't think that was my point. That's not all my concern about whether he's consistently conservative. I don't know what that means.
And on McGirt, I think it's also important to note that that decision did not declare the state of Oklahoma to be Indian territory for all purposes. It was for the purposes of the Major Crimes Act, which is a very different thing. And in my view, that was a correct reading of the text, and admirable that Justice Gorsuch read it that way.
I keep on trying to think about sort of other examples, and the one that sort of comes to mind here, where I do think there's a kind of literalism. So imagine we have the freedom of speech claim, right? And then the question becomes, well, should freedom of speech protect perjury? And you can easily imagine someone saying, making all these types of arguments. Well, freedom of speech means speech. That's the literal meaning of it. And, we can't bring our own values into it. And so freedom of speech needs to be understood that way. And if they didn't expect that, well, they didn't expect it. Now, my sense of it is that one needs to look at the context at the time. It's not that their values, the primary argument is not that their values didn't believe in perjury. They had an understanding of freedom of speech as being a system of liberties that excluded certain things like perjury. So it's not like there was unambiguous text there allowing the result of protecting perjury language. Instead, we've got an ambiguity, and given the context, and it seems pretty clear that they would have meant freedom of speech. And someone would say, of course, freedom of speech doesn't mean protecting perjury. Yes, it's speech, but it's not part of the system of freedom of speech we're referring to. I think there's a parallel here with discriminated against because of sex. There was sort of understandings of what it was. It didn't cover every possible distinction between people. The only way that Gorsuch gets the distinction here is by using the but-for causation standard, but we're all very familiar with the idea that but-for causation is over-inclusive. If I get into a car accident, a but-for cause of it was my mechanic in the morning, fixing my car, left the car perfectly fine. If he hadn't fixed the car, I wouldn't get into the car accident when I ran the red light. We're all familiar with the idea that but-for causation is over-inclusive. And so it wouldn't be surprising that using a but-for causation standard of that sort would get us things that are broader than what might have been employed if we actually sort of talk about how people were using the term at the time, in the same way we have with a sort of First Amendment.
So I want to get to your first point, which I think is a really important one about freedom of speech. I think there is often an assumption, and maybe this is an assumption that the panels today will discuss, that constitutional interpretation and statutory interpretation are the same thing. And whatever approach one adopts in the statutory interpretation context necessarily carries over to the constitutional interpretation context. And I think there are probably some things that carry over, but I think it's also important to analyze these as different enactments with different the Constitution came about in a very different way than a federal statute is enacted, and it had a ratification process that does not exist for a federal statute, right? A federal statute goes through Congress and is not ratified by the public in state conventions. So I think or by state legislatures. So I think it's really important for us to concentrate on those procedural differences before we automatically assume that any approach in statutory interpretation will carry over to the constitutional realm.
Unfortunately, we're just about out of time. Do you have anything you want to add? And just like very quickly, Press Propin? Okay, well, so we're just about out of time. We could obviously go on for quite a long time, but I want to thank the panel, and I want to thank the audience for coming, and to encourage everybody to come to the continuing panels, which are going to continue through the day. And thank you very much.
Thank you. Thank you.
Thank you. It was good to see you guys.
Likewise.
Thanks.